Thank you very much. It's a great pleasure to be here. I was saying to somebody before I came up here that when you get invited to the National Humanities Center, it has the property of making you know exactly where you're being invited to. That is, the building's very famous and very beautiful, and it is a very strong reason to accept. And I think some of us are here just because it's such a beautiful building and because every time we're here we have learned and thoughtful conversations. So I wanted to thank the National Humanities Center. I also want to thank the nice lady who came up to me just before I started and showed me her Canadian pin on her lapel. There appear to be some Canadians here, so it's wonderful to see you, fellow compatriots. We're a small Masonic order in the United States of immense power and influence, so you've been warned. We're out there. And, it's also very nice to be here with terrifyingly erudite men and women who I've learned from all my life. Two of them are in the front row staring at me beadily. It's a scary business, and it isn't less scary for the fact that we were in graduate school together. They become learned and famous, and I've got to be on my best behavior. So there we are, and it's also a great honor to be here with Jean Elshtain, who is a woman who has the admiration of us all, which is also a transparent request on my part for you to go easy on me, Jean. But she will not do. She's not that kind of person. My title is an odd one. It's called, Do States Still Have the Right to Be Wrong About Justice? And it's an odd title, and it came to me because I read this phrase, the right to be wrong about justice, in a very interesting book, which I commend to you, by a young American legal scholar called Brad Roth, and the book is called Sovereign Equality and Moral Disagreement, and in there is this sentence, and I'm going to read it to you because it sets the problem up so well. The claim for the normative significance of state sovereignty is partly based on an attribution to discrete political communities of an ample, though not unlimited, moral right to be wrong about justice. Outsiders, even when objectively correct in condemning internal practices, have a presumptive moral obligation not to interfere coercively in collective enterprises of which they are not a part and in which they hold no direct and permanent stake. That's a complicated sentence. You didn't need to get it all, but you get the general drift of what's going on. That sentence is a very strong challenge to human rights as we know it, and I want to explicate that and give you some thoughts about essentially the question of whether states do have a right to be wrong about justice. And a right, let's distinguish from a capability. All over the world, there are states with a capability to be wrong about justice. That's easy. Everywhere you look, states are abusing, sometimes violently and in terrifying ways, the rights of their citizens. So the question of whether states have a capability to be wrong about justice is not the least bit interesting. The more interesting question is whether they have a right to do so. And if so, to what extent they have a right, how far they have a right to be wrong about justice. And I think the point that Brad Roth is making is that, and it's an important moral point, is that state sovereignty is not just a kind of Westphalian leftover, a kind of bump in the road towards moral universalism. State sovereignty is more than something vestigial and left over that we're getting beyond as we move into a globalized world. State sovereignty is actually the legal guarantee of moral pluralism in a globalized world. And we want moral pluralism. We want to value moral pluralism because we don't agree about justice. We disagree about what is just and true inside our societies, and needless to say, we disagree between societies, between religions, between faiths. We live in a pluralist world. And the Brad Roth point here is that state sovereignty is the legal guarantee, the institutional guarantee, that we can live in a morally pluralist world. And the right to be wrong about justice, therefore, derives from the right of self-determination. So right away, we've got a problem here. The right to be wrong about justice, in turn, derives from a human right, which we value, the right of self-determination, the right of people to be masters in their own house. You can't be a master in your own house unless you have the right to decide what is just and unjust in your own house. And so here's an interesting fault line, which we've understood to be in human rights since the beginning. The conflict between the self-determination claim, the right to be master in your own house, sometimes runs against individual human rights. In a way, you could say the coercive authority of human rights universalism is checked by human rights itself, is checked by collective rights of self-determination, the collective right to be right about justice and the collective right to be wrong about justice. And normatively speaking, the sovereign equality, the doctrine that all states are equal, the doctrine that states should be inviolable from external interference. I mean, why does this matter? It's, again, not just a pesky impediment to a better moral world full of universal principles. It protects the weak from the strong. So there are some very strong moral principles behind, normative principles behind the idea of sovereignty. And we ought to think, that's, I think, the challenge that Brad Roth wants us to think about. But let's then gloss this a little further. We all know that there's a difference between self-determination and democracy. And so then the question becomes, do only democratic sovereigns have the right to be wrong about justice, right? That sounds right to us immediately. If you're democratic, immediately your conceptions of justice will be more legitimate to external authorities than if you're non-democratic. So then the question is, do only democratic sovereigns have the right to be wrong about justice? And then let's get to an example where this focuses clearly. Is the Texas death penalty legitimate, but not the Chinese death penalty, right? Both are expressions of the self-determination of a people, but Texas, clearly, the people of Texas, whether you like it or not, whether we like it or not, whether we agree or not, believe that the state ought to have the right to take life, and that's ratified by the people of Texas. Does that have more legitimacy, therefore, than death penalties in states that don't have that democratic warrant? Second kind of example is, does the denial of gay rights seem more legitimate in Turkey, because Turkey is a democratic society, than it does in Saudi Arabia? From my point of view, that's being wrong about justice. I'm a firm and passionate believer in the gender rights and gender equality of all human beings. But are we going to say, because Turkey is a democratic state and believes that gender equality goes against the Quran, that they have more right to be wrong about justice in Saudi Arabia, where nobody's got a say about anything? The answer, unfortunately, in international law is pretty clear. Sovereignty is sovereignty. Sovereignty protects the rights of the just and the unjust alike. It protects the democratic and the undemocratic alike. Sovereignty is just sovereignty. Everybody under the norm of sovereignty has the right to be wrong about justice. And all of this gives us a problem when we think about it. Where does it leave human rights advocacy? Where does it leave the faith that I profess, the faith of a certain kind of moral universalism, the sense that we're all human beings here? and that what is wrong in North Carolina is wrong in Toronto, is wrong in Beijing, is wrong in Turkey, is wrong everywhere. Where does it leave that faith? I think the thing that I have come to see is that there is a real fissure here in how we think about things. From a human rights perspective, justice is a universal, and sovereigns have no right to be wrong about justice. They have the capacity to be wrong about justice, but they have no right to be wrong about justice. And in a concept of human rights universalism, democracy and self-determination may be rights, but they don't trump other rights. And so the death penalty and other rights violations are wrong always and everywhere. It's bad in Beijing and it's bad in Houston, right? Denial of gay rights is bad in Turkey, it's bad in Saudi Arabia. It doesn't get better if it's ratified. If the denial of rights is ratified by a democratic legislature, it's bad. That sense of moral universalism cuts right across the idea that sovereigns have a legitimate right to be wrong about justice. And so there's a fissure at the heart of what we believe, and we need to be honest about it and think about it and try and find some way to think through these contradictions. My sense of this is that in reality, after 60 years of human rights promulgation through the UN system, we're no nearer than we ever were to superseding sovereignty as a principle of organization in international affairs, and we're no closer to superseding its moral weight. That's my point. What has changed, I think, is that human rights as a language has created a new audience of justification and a new burden of justification for everybody, sovereigns and non-sovereigns alike. It's created a new audience in which sovereigns have to justify what they do, and that, it seems to me, is a 100% good thing. But it hasn't changed one iota of the normative fact that sovereigns retain the right to be wrong about justice. Not merely the capacity, but the right to be wrong about justice. So where does that leave human rights advocates, if that's the case? And here I think the acknowledgement of the weight of the right to be wrong about justice, I think, does have a significant inflection in the politics of human rights. I think that on human rights issues, citizens have more standing than non-citizens on all human rights issues, in both democracies and non-democracies alike. In democracies and non-democracies alike, citizens count more than non-citizens in determining the question of whether their state has the right to be wrong about justice. Insiders matter more than outsiders. They have more legitimacy than outsiders, in my view. That, again, is not a familiar or friendly thought, because moral universalism has created this global civil society of activists, and we like to think that all global civil society activists are equal, and I'm saying actually they're not. Insiders have more rights than outsiders. They have more claims to be listened to. Some of that's intuitively obvious. They certainly will have more political effect. If you want to change the Texas death penalty, it'd be a good thing if you were born in Texas, raised in Texas. So instead of being an outsider, you come into the Texas legislature and say, I was born here and I think it's an abomination. You're going to get a better hearing than if you're some kind of Canadian coming in from outside, right? I mean, these are intuitively obvious things, but they point to an important differentiation in the moral status and standing of outsiders and insiders. And when you have to choose, here's where it gets tough, where external and internal justifications clash, the justifications offered by citizens deserve to win. That's an important point. If a human rights abuse isn't a human rights abuse to insiders, outsiders haven't got a chance of making anything happen. It's just, it has to do with the moral legitimacy and your relationship to the political community in which you speak. And that, I think, human rights advocates have to understand. Let me give you an example or two of this. I guess what I'm saying is that, and again, this is an uneasy thought to get your mind around, human rights is the great example of global politics, global civil society politics. And I'm saying something very different. I'm saying all human rights politics is local. And all human rights politics has to be local to have legitimacy and political effect. Let me give you an example. Aung San Suu Kyi is taking quite a lot of heat from external sources at the moment that she's too cozy with the military. I'm here to tell you it's Aung San Suu Kyi's darn job to decide how close she gets to the military. Outsiders can talk to her, but she has to make that call, right? It's her society. It's not my society, right? We can talk to her. It's legitimate for us to say, Aung San, you're getting too close to the military. But she has the legitimacy. The internal legitimacy of having suffered, the internal knowledge of her society, she has to be the one to make that call. Similarly, if you talk to gay rights activists in Uganda and Malawi, they have a real dilemma. They are being persecuted, but is it in their interest to have Western governments shut off the water to Uganda and Mali? Should aid conditionality in Malawi and Uganda be tied to the gay rights issue? I think it's very important to listen to gay rights activists who say, you're putting us in jeopardy if you do that. That is, let us be the judge of what the politics ought to be here. The issue is not whether what is happening towards gay activists in Malawi and Uganda is wrong. That's the easy part. The hard part is the politics. What do you do? Whose voice should count here? And I feel very strongly that internal activists have more legitimacy in these issues than external ones. Let me take a still more controversial example, which is Libya has got Senussi, the head of the secret police, under Gaddafi, and they've got Gaddafi's son. Should he be tried in the ICC in The Hague, or should he be tried in Libya? It's a great example of this conflict that I'm trying to describe to you, and my very firm view is that if Libya's got it, Libya should try him. And I say that even though, here's sailing right into it, I'm deliberately trying to create controversy here because it's a controversial call, that's my point. He may not get as fair a trial as he would get in The Hague, and he may get the death penalty. But if you have to choose, and you do have to choose, it seems to me Libya has the right to try its own. See, these are uncomfortable issues. I'm not 100% satisfied with my own answer, but I'm trying to get us to feel the discomfort of these choices so you understand that what I'm saying there in the Libyan case is that Libya has the right to be wrong about justice. And what being wrong about justice in that case means Senussi hangs, right? They have the right to do that. I'm opposed to the death penalty, by the way, just in case you think I'm wobbling around here. I'm opposed to it. But in the choice, it seems to me Libya has got the right to be wrong about justice, and the ICC's attempt to extradite him on grounds of a fairer trial and the fact that we won't execute him, I don't see the moral warrant for that. That controversial cause, and I hope we'll have a discussion about it. Now, I have gone a long way to saying human rights politics is local. The claims of determinate political communities to be wrong about justice seem to me very strong. Okay, what are the limits here? How far are you prepared to push that? In certain cases, obviously, where human rights norms are incorporated by consent of a sovereign, and this is how human rights becomes constitutionalized, sovereign states around the world incorporate into their constitutions or into their domestic law human rights instruments. To the degree that they do that, they agree to be bound by international norms, and to the degree that they are bound, they agree that they can no longer be wrong about justice. To the degree that they voluntarily incorporate these norms, then they're bound. And they can be held account according to those norms, but lots of countries refuse to incorporate those norms or incorporate them with reservations and understandings and declarations, the United States being an example. The international community doesn't like the fact that when the United States incorporates international human rights norms, it does so with reservations. Seems to me this is the right of the United States to be wrong about justice. Those human rights activists who regard RUDs as being somehow a kind of fault line in the international human rights architecture, I don't think understand the force of sovereignty as a moral claim. People simply seem to argue as if the sovereignty claim is simply a force majeure or a power claim. I think there's a normative claim that needs to be taken seriously. Clearly, lest there be any confusion, where sovereigns commit crimes against humanity, ethnic cleansing, massacre, genocide, actual or apprehended, it seems to me they forfeit their right to be wrong about justice. There have to be limits here. And the limits are the grave human rights violations that became the basis of the doctrine with which I was associated when the R2P doctrine was put together, the idea of sovereignty as responsibility. The core idea and the idea of sovereignty of responsibility is you could do lots of stuff in your backyard, but you couldn't chop human beings into little pieces. And if you did, you forfeited any claim to be, any right to be wrong about justice. And where those crimes become a threat to international peace and security, needless to say, intervention may occur. But let me go on and be still more controversial here. I was part of the International Commission on Sovereignty and Intervention, which came up with the doctrine of the responsibility to protect and the doctrine, correlative doctrine of sovereignty as responsibility. And I'm proud of my part in that work, but I would have to say that even in mass atrocity cases, even where the limit of a sovereign's right to be wrong about justice has occurred, I think intervention as a practical matter will never be a responsibility of states. It'll always be a discretionary right. That is, the attempt to think about sovereignty as responsibility was an attempt to think about humanitarian intervention differently, to think that when horrible things happen in another sovereign state, a sovereign has a responsibility to act. One of the reasons that the United States and major powers has so resisted the doctrine of sovereignty as responsibility is they don't want the responsibility to intervene when countries are incorrigibly wrong about justice. They want to have a discretionary right to intervene as and when they think it's a good idea. And that's a very different thing. Understand the difference between responsibility, which is coercive and compulsory, and right, which is discretionary. Intervention will always be a discretionary matter. And power and interest and oil and humanitarian conscience, God knows what will go into it, but it's not going to be a compulsory responsibility in any normative sense we can make sense of. So even under the norm of sovereign responsibility, I think what we see is that responsibility to citizens will come before responsibility to any set of citizens beyond. Responsibility to your own will always come before responsibility to others. And I think even responsible sovereigns will end up having the right to be wrong about justice. And all of this is tough stuff. It's unpleasant to think about. I don't even like some of the conclusions I'm drawing. But I am fiercely committed to a morally pluralist world. That is, I'm fiercely committed to the idea that in this room, in this little political community, we do not agree. We do not agree. And forcing agreement